Hello everyone, and thank you for joining us for today's presentation as part of the Industry Insight webinar series. The topic this time is good billing habits, what they didn't teach you in law school. Speaking today will be Janelle Benefield and Claude Duclos from LawPay. Janelle Benefield is LawPay's Programs Director. With over 15 years of experience in the credit card processing industry, she has an in-depth knowledge of the challenges law firms face. Janelle brings enthusiasm to helping law firms better understand the world of Visa and MasterCard. Claude Duclos brings 40 years of experience to the legal community as an attorney with a focus on civil trials, business formation, transactions, trials and appeals, mediation, and arbitration. With his knowledge and expertise, Claude brings a unique and informative perspective in the area of legal ethics and professionalism. He served as chair of the Board of Trustees for the Texas Center of Legal Ethics and Professionalism for 2 years and has written extensively on legal ethics issues. Among other ventures, Claude serves as an industry liaison to LawPay. The Industry Insight webinar series is hosted by the ABA Legal Technology Resource Center. To stay updated on upcoming webinars or view previous videos, visit ambar.org/industryinsight. You can also stay updated on legal technology news through our blog, www.lawtechnologytoday.org. Thank you all for joining us, and we'll now begin the webinar.
Hi, thank you very much. This is Claude Duclos. Now, I'm really excited about giving this. I do a lot of CLE speaking, but this is something that I don't think you learn in law school, and you really kind of learn over the 38 or 40 years. Let me tell you this. Billing a client starts way before you actually sent the bill. Getting that relationship with the client starts very early. So here's what we're going to be covering today. How to interview clients. Lawyers don't know, and law schools don't teach you. What you should include after you finish that interview in a good fee agreement. Setting your billing rate, how to set a billing rate for success in your practice. And then developing good habits and keeping reporting and billing your time. And some practical hints that I have learned over the years to help me do that and stay on top of it. The psychology of getting paid by clients, and then quickly we may be talking about the appropriate use of trust accounts. Now, we only have about 30 minutes, so let's go into this as quickly as we can. First of all, we don't know how to interview clients when we get out. You have to, first of all, form this psychological relationship. As any psychologist will tell you, healing begins when people think they're being listened to. So listen, close down your email. Don't take any calls. Don't take any text while you're interviewing a client. Make sure that client knows that you're listening and hanging on every word that he or she says, because you might have questions. It's going to help you understand this person. I always say, since we don't have a lot of time, there are 2 questions that I've learned you must ask your client all the time, your prospective client, and that is, what, in whatever manner you want, what do you think I can do for you? In other words, what are your expectations? That way you'll find out if your client is from the planet Earth or from another planet. If they say, well, my brother had a case like this in Baltimore and got $5 million, and you're thinking, this is a $20,000 case, you have to realize you either have to pass on that case or talk this prospective client down to reality, or you will never make this client happy because they have unreasonable expectations. So that's question 1. The second question I always say, which always opens a Pandora box and doesn't appear on this slide that you might be looking at, is, all right, you get to be a fly on the wall in the other lawyer's office where your proposed opponent or your spouse, who, whatever the thing is telling them about you. What are they telling their lawyer about you? It's amazing. You've just opened this Pandora box, because they will now tell you, because they're protecting you from this, that, oh, well, they'll say I'm an alcoholic, I've been through bankruptcy 3 times, I have a terrible thing, and you're my 4th attorney. This is nothing that you learned in the interview, but now you've asked them what the other person is going to tell you, so it's allowing them the leeway to protect you. Always ask those 2 questions. What do you think I can do for you, and what is the other person saying? The other thing I say is, now, what's your reason? It may become very clear during the interview why there is, but if they say, I am doing this for the principle of it, that is a very bad answer. You have to know you will never make a client happy who is pursuing a case for the principal because they have unrealistic expectations, and if they want $1 million and you only get them $999,000, you have failed that client. So make sure you have that. All right, once you have set reasonable expectations, what should be in your fee agreement? Obviously, some of these things are easy. Make sure it's in writing. The scope of the work. I'm going to handle a probate for you. I'm going to handle a divorce. I'm going to handle the formation of a corporation. Make sure you identify the client, who the client is. If two people come in, who's going to be your client? Make sure you identify that. If I'm going to be the corporation's client, I won't have any secrets that I can keep from either one of you. If I'm Bill's client, he'll be my client if Mary's going to be my client. The basis of the fee, is it hourly? Is it a contingent fee? Who's going to be working on it? Is it going to be me? Name your legal assistant or associate and their billing rates. How will they update you? I say if you can communicate with your client regularly, even with 1 or 2 sentence emails, you will never have a grievance against you. Always keep the client informed. Give them their office hours, the amount of the retainer, and you should always disclose if it goes into your attorney trust account. In most states, unless you do a separate account, it will not gain interest. So make sure you lay down that parameter. Okay, the other thing, let me talk about some additional contract provisions which I use, which the clients really like, and that is I put in a little client's rights section saying you have the right to be treated with courtesy and respect. You have the right to be treated, to have all of your communications returned within 1 business day, and those sorts of things. By the way, at the end, they're going to show you my email. Anything that you want from me in terms of these forms that I'm talking about, I am more than happy to send them to you in Word format, and you can use those and have my email, and I just have a huge resource of forms you can use. I always put in a rejection of settlement offers, a procedure for a second opinion. Let me just say this clearly. You should never object to your client wanting a second opinion. After 39 years now, I still say if another lawyer can figure out something better, you should try to find out what that is. So always give them the right. It gives the client a great sense of comfort that you will allow them to get a second opinion on what you've told them. Now, always put the payment provision in your home county. These bills are paid in home county, whatever your state is, so that if a dispute arises, you know the venue will be in your home county. We're going to talk more about disputes, but make sure that's in there. And then withdrawal rights or termination by both parties. I always have a right, if a client wants me to do something, even if it's not unethical, if I completely disagree with it, I have the right to withdraw. I don't play that way. I don't do what a client wants me to do just because he wants to hurt the other party or do unnecessary litigation or unnecessary discovery. And I will put it in writing. I disagree with this tactic. If you make me do this, I will withdraw from the case. If you have to employ other counsel, if it's a probate or you have to get somebody to come in as an ad litem, let them know. And then I always put in, and of course in Texas it's mandatory that you either have a sign or you move forward in your contract how they can contact the State Bar of Texas. The other thing is, there's another thing in the fee agreements that I did not put in that most states nowadays you have to have a little privacy policy. That's coming. If it's not in your state yet, it is in Texas, and yet most Texas attorneys don't know about it. Now, again, I have privacy policies. It doesn't have to be 5 pages. It could be 2 paragraphs, 6 lines long, that says what your privacy policy is. Simply, you do not share private information, your entire staff is trained, etc. So put in a privacy policy. Now, the practical considerations for you in any agreement is have it in writing. Make sure you've had that reasonable expectations with the client, and make sure you talk about how long this is going to take. Many clients think, oh, this will be over in 60 days. No, this could take as long as 2 years. This could take I also discuss options. I may be able to solve 85% of your problem with a couple of letters. Is that good enough for you? So make sure they know what the options are. And they say, but that last 15% may be a lawsuit. Never underestimate fees. In fact, the best rule is don't estimate your fees, because the client will only remember the lowest fee you quote and not the basis. They'll come in and say, my wife and I have agreed on everything. We have everything. We've agreed on how much will this cost? And you say mistakenly, oh, this will be $1,500 including filing fees. Then when you're in your second injunction hearing, they'll say, you said this was going to be $1,500. They forget that they said it was all agreed to, and it's not. And then finally, how does this client plan to pay you? Look at this client. Look at this client's history. Don't turn off your common sense. If this person doesn't have the money and can't pay you, you are stepping into a trap. Make a common sense decision if this is a good piece of business for you to take. And I hate referring to clients as piece of business because I don't. I look at myself as a problem solver. But I've gotten really good spider sense tingling when I say, this guy's never going to pay me. He'll give me a retainer that his brother will loan him, and that's going to be the end of it. Just use common sense in doing this. Okay, so how do you set your hourly rate? I always say, for young lawyers, they may not know how to set the hourly rate. So you can't charge more than what's reasonable and necessary in your own community, and you can't charge more than what's a client's likely to pay you for your level of skill. But you can't charge less than you need to support yourself and often your family, given all the resources. And that means if your spouse is employed and brings in income, if you're totally relying on it, you need to make sure you set your hourly rate in enough that you need. So step one is, what do they charge in my community? Pick up the phone. Lawyers are pretty great about saying, well, I think I charge $275. I don't think our town really charges more than that. The other thing that is really a huge resource is ask the judges. Go to the courthouse and say hello to a judge and say, listen, I'm signed on and there's a case that I may be able to charge attorney's fees. What do you charge? I know that there's a specific judge in our community here who has a list and says, if you're board certified, I will pay you $50 an hour more. If you're not, you're going to get, this is the maximum rate I pay to lawyers in our town unless you're board certified. So the judges are really good sounding boards on what's reasonable in your community to be charged. Okay, the other thing is, how do I figure out my personal budget? Now, I do a whole speech on this, so I hope you'll get these slides, but you have to know how much you need. Your macrocosm of success is how much do I need to make in a year. Your microcosm, how much does that translate to each day? A true, honest appraisal of all practice of law is, if you can bill and collect 4 hours a day, you should be able to practice law successfully. And the amount you need is your personal budget and overhead. It should result in an amount that is 4 hours a day, 5 days a week, 20 days a month, about 80 hours a month divided by your overhead. If it results in an hourly rate that's $500 or $600, you're not going to make it. I promise you, you're not going to make it. So let's go on to the next slide here. The 4 hour per day method is you add up all your bills, your personal bills, mortgages, groceries, car payment, what you need to put in your household budget. If maybe less if your spouse is employed and bringing, or you have a significant other who is employed and you're sharing a budget. But let's use the example. If my personal budget is at $8,000 a month for everything I need, and my law office costs me $45,000, I need $12,500. Divide that by 80 hours. That's 20 billing days at 4 hours a day. That's only an hourly rate of $156 per hour. You know what? You can make it as a lawyer under that 4 hour per day method. So as long as your resulting hourly rate is when the accepted rate in your community, as I say, you're golden. You can look at your billing at the end of each day and say, I'm going to make it because I can do this. As we see from that previous slide, the rate of 156 hours may be low. So if you can charge 175 or 200, your office will succeed. So all you have to do is check each day to see if you have the confidence. Okay, now, billing and collecting. You might as well just be taking a jog around the lake if you don't know how to bill. You need to get your bills out the door and create the easiest path to get money in the door. This requires a good billing system, really good discipline and billing habits, which means a daily writing in of your time. And having a wake, clients can easily pay you when the bills arrive, and then you incentivize the clients to use that system. The reason I agreed to do this speaking for LawPay is that it's been an amazing attribute to my practice. I started using LawPay in July of 2015, and by the end of the year, 80% of my billings were coming in on credit cards. Automatic billing is great. They can hit, you'll see just a thing, and I really honestly, personally believe in how great the system works. So you have to incentivize them to use that system, and then a constant follow-up. At the end of the month, if I see that Bob Jones hasn't paid his bill for doing his will, I immediately send Bob a little email and say, hey Bob, I noticed you didn't hear it. I'm sending you a link. You can pay it with your credit card. And the 3 times I did this at the end of January, boom, all 3 of them were paid immediately with their credit card. So, always record your time daily. The reason I have honestly had a 97% collection rate, and that's because I absolutely, at the end of each day, I look at my outgoing email, because that'll always give you a tip. It'll always refresh your memory as what you worked on. And don't use shorthand in those things. Say, I talked to Bob about the upcoming hearing, right? Talk to client about hearing. Make it personal. Make it so they will recall that. And oh, by the way, legal tip, don't reveal confidences in your billing, because if you seek to have your fees ordered by the court, you have to do the entire bill and have them shown under Texas law. That's Texas law, and I bet it is in other states. So always just never reveal confidences. Okay, throw in entries at the activity at no charge when you talk about, oh, talk to client and send him copy of letter. Point 2, no charge. Throw in no charge thing. That's great. Here's stupid things that I see lawyers do, really stupid. Making the stapler a profit center, charging them for binding, office supplies, $1 a page for, that's just stupid. Sorry, there's no other way to get around saying that. And then charging a surcharge for the use of credit cards. I love paying my 1 to 2%. Let them keep their points. That's what they want. If you're going to say, well, now I'm charging a credit card, first of all, it's illegal in some states, but you have to do all this other accounting if you're going to do that, and it's much too complicated that I can explain. Clients love getting their miles and their points and everything, and I don't mind getting the money in and paying. What it leads me to do is, if I can do another 1/10 of an hour of legitimate work for that client, I cover my fees. Don't charge excessively for legal research or using bland description, file review, 0.2 hours, or file update. Don't do that. That's stupid. It makes clients mad. And don't charge too much for copies or faxes. Now, here's the past success. Timely billing. I say, in my old Catholic background, it's a mortal sin not to get your bills out on a set day. Mine go out absolutely on the first day of the month. The client satisfaction curve is this. The best day to bill them is on day 0 when you've just done the work. After 30 days, they think your bill is high. After 60 days, they think you're insane. And after 90 days, they've convinced themselves they didn't even need a lawyer. So those big firms, I've talked to so many clients, the big firms, a bill, an October bill comes in late January. They're already mad about it because it's been 3 months and now they don't even remember any of that stuff. Client is happiest at day 0. Get the bill out on the first day of the month. Always give the clients an option of emailing them their bills. About 1/3 to a half always want me to email their bills, and most younger clients don't even use checks. So email it and have a payment link, which we'll see in the next slide, so they can put it on a debit card or credit card right away. Here's what I do. You see, when I send out the bill, look on the left of this slide. Here's my dear great client. You'll find your regular invoice. And then I have a little blue make a payment. Actually, mine says pay Claude now. And they click on that, and then you see on the right, that's what comes up. All offices of Claude Duclos, where I am. It has all my details on it, and they can just put in right then the amount to pay, their cardholder information. They only do it once. Then they get an email saying they paid. I get an email saying they paid. It's a great system, I'm telling you. My deepest part of my heart. So, and then on my website I have make a payment, so they can click on that. So it's there too, and they come up to that same payment screen right there too. So how do you resolve billing controversies? You ask yourself, what's the timing of the controversy, where it is in the case? It's likely the client will ever pay me. Never sue a client unless it's an existential threat to your practice. Counterclaims are compulsory. You're going to get sued if you sue your client. I hope you can see this. I'm going to move on a little to our next slide. So That's, where are we? I'm not seeing, no, I'm not seeing the next slide. Okay.
Should say hand me the hem.
Nope, I'm not seeing that. So that's hand me the hemlock. Don't sue clients. Oh, here we go. Unless your economic survival pays on it. Why? Because my good clients who run out of money always try to work out a deal with me. Bad clients will remember things the way they want to, and you will get counterclaimed, and they'll remember all this horrible stuff that never happened, but you'll be backpedaling about why you need that money. So you're going to get sued. And I say you'll make more money with new business. If you're having to sue a client, you made a mistake in taking that, and you didn't get out soon enough, so you have to kind of fall on the sword about that. Don't sue your clients. So let's go to my final thoughts here. Interview the way which results in reasonable expectations, how long it's going to be, what that client knows, have a written agreement, communicate early on and often. Have excellent billing habits. Bill daily. Don't wait 3 days later. Put that time in at the time. Promptly send out your bills and make it easy for that client to pay you. And then don't sue if you get burned. It's just all part of using business. Final thing is, if you have a billing controversy, I love fee dispute committees. I've been on several, appeared before many. They really try to work hard and be fair to both the lawyer and the client, and that's the best way of getting it done. So those are my final thoughts, and I want to pass it over now to Janelle Benefield, who will tell you the wonderful technology we have. Thanks, everybody, for listening to this. Go ahead.
Thank you, Claude. So this is a quick introduction into LawPay and what we do. We're a payment solution designed specifically for legal professionals based out of Austin, Texas, and we've got over 10 years experience processing payments in a professional, modern way. And so we've developed a proprietary technology that is PCI compliant and helps attorneys be able to accept not only credit cards but also debit and check cards in a professional manner and make sure that not only the card holders are protected but the law firms are protected as well. LawPay is the preferred payment partner for 25,000 attorneys across the country, and the reason that we're different is that if you want to accept a retainer payment, for example, by credit or debit card, we give you the ability to take a $5,000 retainer, for example, and deposit the funds directly into your trust or your IOLTA account. If you're taking a payment for a past due invoice or work you've already completed, that $1,000 can be directed right into the operating account. And the key to our program and the reason why we're recommended by 42 states and 50 metropolitan bars across the country is that any credit card processing fees associated with either transaction are only deducted out of the operating account. And so we make sure that we're safeguarding, we're protecting the trust account funds, making sure that you're compliant. And so this gives you the ability to accept credit card and debit card payments with confidence and know that the funds will be handled correctly. So how is LawPay different? The first thing we do, which, thank you, Claude, for showing what you do in your own firm, we create a customized payment page for you or for your firm. And so we create a page that's professional, modern, that utilizes your logo and your branding, that's easy for you to use internally and for your office admin, but most importantly, it's easy for your clients to use. It's, of course, secure, and it's a client's preferred method to pay. We hear stories all the time in the office how surprised people are, how easy it is, and how much their clients enjoy using the payment links when they're including them in their email correspondence and on their websites. So let's take a look at 3 ways that successful firms utilize the payment page within their practice in order to make it easier to get paid. And the first thing we do, as Claude has shown, is adding a hyperlink to your email correspondence. If you are sending out electronic invoices, a very easy way to use our program is including a pay invoice link, or it could even just be text, click here to pay. And that gives the client the ability to click on that link, and then they're taken onto a branded payment page that has the firm's information on it, so they know they're in the right place when they're making their payments. And then they can type in the dollar amount they want to pay, the invoice number, the matter number. We can collect any amount of custom information that the firm needs for reconciliation on that particular page. But most important thing is it looks professional and they know that they're making a payment to your firm. Another way that you can utilize the payment page is if you're using accounting software such as Xero or FreshBooks, maybe even QuickBooks Online, then you can add a link to that same payment page in your invoices, and sometimes that looks like this green Pay Now button that we're seeing on our screen. And so you, again, if you're sending your invoices out of Xero or QuickBooks Online, you can easily add that hyperlink, and when they're opening up your bill, there's a link and they can pay now. And then the third way that we see firms utilizing that payment page is by adding that same hyperlink and adding it onto their website. Most of our firms are putting it in their main navigation, and they're including things like click here to pay your bill, make a payment, something of that nature in their main navigation. And that way you can easily direct clients that are calling in over the phone or in your invoices that they can pay online and direct them back to your website. And we found it's actually a great way to market your website, because now you're starting to drive traffic back to your website on a regular basis. And so that gives you an opportunity to market changes in the firm, things of that nature, new types of law that you're taking on, or maybe you've added a new attorney to the practice. And so driving people back to your website is a great opportunity for you to communicate on a regular basis with your clients. And then on the LawPay program, we do have some customized features that you can take advantage of. Of course, we can create custom pages for your front desk. If you want your receptionist to be able to take a payment as clients are leaving, we can certainly create a specific page just for those payments. Also, if you have different types of law that you're practicing that you would like to track, you can use different pages in order to reconcile or tag that information, so this was a family law case versus this was maybe a bankruptcy case. Or if you have different attorneys that are working in your office and you want to know which one belongs to John Smith versus Alan Smith, then you can again have different pages for different attorneys. We also offer recurring payments, and so we're starting to see more attorneys getting comfortable with recurring payments, putting payments out into the future and letting the system automatically draft clients on a specific date. If you have annual renewals, if you're in estate planning and they're, every year you're taking a payment from your existing client base, that's a great way to automate it, so that is now becoming an automatic process and a little bit easier for the office to manage. And also, now that we're starting to see large retainer payments coming in on our payment pages and people are refreshing their retainers, we have the ability to collect a digital or electronic signature. So if someone makes a large retainer payment of $10,000 or $25,000, you can send them a request through the LawPay portal and say, thank you for the payment. We just would like a copy of an electronic signature for that particular transaction. And so we have several different options there to help protect you when you're taking those large payments. Now, our system is also integrated if you're using a practice management program. We have lots of partners that we have direct integrations with, and so we want to help you get paid. And so this page highlights some of our practice management partners: Abacus Data Systems, CaseFox, SynCompass, Clio, Cosmolex, Logiforms, Practice Panther, and Rocket Matter. If you don't see your practice management solution on there, give us a call. We're always interested to offer more options to our firms in order to help you get paid. If you're using billing or accounting software, we also offer integrations there as well. And so here are a few of our billing and accounting partners, which include Bill for Time, Chrometa, FreshBooks, Invoice Sherpa, Time59, TimeSolve, QuickBooks, and Xero. And so if you're utilizing any of those programs, we do have the ability to connect your LawPay account and again just give you another tool. So we want to make it as easy as possible for clients to make payments and remove any hurdles or any procrastination reasons they're not paying. We want to give you the tools to make it easy and get those payments in the door. So just a quick wrap up, some benefits of LawPay. We offer live support. We handle the trust account deposits and the associated fees properly to make sure that we're safeguarding or protecting your trust account. We offer modern payment tools with our payment pages that give attorneys the ability to maintain their branding and their image, and also give clients an easy way to make payments by either credit or debit card. And of course, we also offer direct integrations with practice management solutions, billing, and accounting software, again, to try and help make it as easy as possible for you to get paid.